Good afternoon, everyone. The House Judiciary Committee will come to order as it is 10 minutes after we left the floor, or 1 o'clock as the speaker had to remind me. Will the secretary please call the roll?
Chairman Briggs.
Present.
Representatives Abney.
Designation.
Carroll.
Yes.
Donahue.
Here.
Hambidge. Here. Hohenstein.
Here.
Howard. Here. Kenyatta. Here. Kincaid. Here. Mays.
Designation.
Pielli.
Here.
Rabb.
Designation.
Sanchez.
Designation.
Schusterman.
Designation.
Chairman Kaufman.
Here.
Representatives Bonner.
Here.
Borowitz.
Here.
Ecker.
Designation.
Ham.
Here.
Kale.
Designation.
Kerwin.
Designation.
Clunk. Kuzma.
Here.
Ledbetter.
Here.
Rigby.
Here.
Shalaba. Mr. Chairman, a quorum is present.
Great, thank you. Secretary, quorum is present. We will proceed with today's agenda. First on the agenda, we're going to go through the agenda, I think in order as it is on the memo, will be House Bill 384 by Representative Ortiz. Council, please provide a brief description of the bill.
Mr. Chairman, House Bill 384 by Representative Ortiz allows courts to order a gambling disorder evaluation as part of a sentence when a person is convicted of trespassing in a casino or video gaming area while on the gambling self-exclusion list. The bill takes effect in 60 days. There are no amendments.
Thank you, Council. The question is, will the committee report the bill, House Bill 384? Are there any comments on the bill? Seeing no comments, are there any negative votes on the bill? Okay, that's great to hear. If the secretary, if okay with the chairman, all members will be recorded as a yes vote. If the secretary could record that. House Bill 384 passes and will be reported as committed. Next on the agenda is House Bill 458 by Representative Hill Evans. She is with us. I thought I saw her. The chair will recognize Representative Hill Evans for brief remarks on the bill. When you get situated, you will be in order. Thank you, Representative.
And thank you, Mr. Chairman, and thank you to members of the committee. House Bill 458 is about giving our veterans the fairness and compassion they deserve by making a simple update to maintain consistency on how we sentence them when they are in court. Veterans are allowed to present PTSD and TBI as mitigating factors during their sentencing for a crime, so it only makes sense to allow veterans who were later diagnosed after their incarceration to petition the court for post-conviction relief and introduce this new information. These are men and women who served our country honorably, and it's not uncommon for their trauma to go unrecognized or untreated for months or even years, and certainly conceivable at the time of their trial and sentencing. We know so much more now about PTSD and TBI affect behavior, judgment, and decision-making. For many of these veterans, those invisible wounds of war may have contributed to the circumstances that led to their incarceration. Justice demands that we take that into account. This bill does not guarantee anyone a reduced sentence. It simply gives courts the opportunity to review a case with the full picture in view. It is a measured, responsible, deep understanding step towards fairness and a reflection of our gratitude to and deep understanding of those who risked everything in service to this country. I ask graciously that you vote in support of this measure to show Pennsylvanians that their government believes in justice and compassion for the service members who gave their all to serve us. Thank you, Mr. Chairman. Thank you, members.
Thank you very much, Chairwoman. Council, please provide any additional information on the bill.
Mr. Chairman, the bill takes effect in 60 days. There are no amendments.
Thank you, Council. The question is, will the committee report the bill? Are there any comments on the bill, House Bill 458? Representative Bonner, you are in order on the bill.
Thank you, Mr. Chairman.
And Madam Chair, I just had a question. I certainly understand the wisdom of the bill relative to its potential impact on a sentence, or even its consideration as a mitigating factor as part of a death penalty case. My question, though, is to expand the potential usage of it to affect a conviction. Historically, for centuries, we have only allowed a conviction or the consideration of guilt or a verdict of not guilty to be impacted when someone suffers from insanity. And I am concerned that the broad nature of this bill would particularly allow for a defense of just mental distress or disability to affect a verdict. So I just wanted to see what your thinking may be relative to the potential impact of a service-related mental health illness that does not rise to insanity to be part of the consideration of a conviction for a criminal offense.
You're saying, what's my thinking on that?
Do you think, is your bill intended to allow for the setting aside of a lawful conviction by a jury simply based on the existence of mental illness that does not rise to the level of insanity?
Only to where it may be service related. So that's why for veterans, it's if something happened to them while they were serving, and as a result of that, and with proper diagnosis, it was somehow missed when they were sentenced, and so this just gives an opportunity for them to just have it reviewed.
Again, I would support the bill if it were limited to consideration by a judge in sentencing of a particular mental health illness or disability that is service-related, or as a mitigating factor in a death penalty case. But I can't support it if it would any way allow for a jury to consider it as a defense and possible basis of acquittal for a criminal charge. I think minimally it would be a violation of the Equal Protection Law of the Commonwealth of Pennsylvania and the United States Constitution to allow that defense for someone who has served in the military, but not allow it for others who suffer from mental health issues. So hopefully we can get some clarification on the bill to limit it to sentencing purposes or defining it as a mitigating factor under the death penalty. But in its current state, I won't be able to support it. So thank you.
I believe Council Vitale has something to add.
Mr. Chairman, this bill is focused on, it's a second look for purposes of a Post-Conviction Relief Act. So this is an individual who's already been sentenced. They're serving time in prison, but through receiving mental health care in prison, they're diagnosed with PTSD or TBI while incarcerated. Their lawyers could go back to the sentencing court and say, hey, we didn't know this existed. Can you take a look at this in full context? Would you have sentenced them the same way if you would have known this? So it's just a second look. It's not giving anyone, it's not changing their conviction up front. It's not going to overturn their conviction. It deals with what sentence they're going to serve out.
I just have, if I could, Mr. Chairman.
Of course.
As I say, if we limit it to that purpose, I would be supportive. I do note, however, in the bill summary where it states eligibility for relief, it says a conviction or a sentence may be challenged. So that's my concern, that the conviction should not be challenged, but the sentence, I have no problem with the court considering it for that purpose.
I think after the meeting or at some point, Representative Bonner, we'd all probably should talk, make sure we're actually looking at the language of the bill and make sure that is there. I would love it if you could vote yes today, but we'll have that conversation. Chairman Kaufman on the bill.
I certainly, think the gentleman's concerns have merit, and I also wonder about the constitutionality of the bill. In Commonwealth versus Sutley, the Supreme Court held that the General Assembly cannot direct courts to open final judgments. The court noted that final judgments of the judicial branch are not to be interfered with by the with by legislative fiat in this Commonwealth has long been established and is no longer open to serious questions. So this bill directs courts to reevaluate the sentences even, even after the sentence has been imposed. And, this has a look back. So I agree with the intent, what I believe the intent of the bill is. But as you list a 16 bill agenda, many of these are just not ready for prime time today.
I would like to note that this was brought to my attention by a judge. He ran the Veterans Courts in York County, Judge Craig Trebilcock, and it was his language and his idea. He also was retired military, and so I can't imagine that he would have overlooked the constitutionality. Doesn't mean he didn't. I just find that hard to believe. But at any rate, we've been working on this over the 6 years, and I was happy to see that at least it was brought to a vote. And I, again, would appreciate a positive vote on the bill. And again, thank you very much.
Thank you very much, Chair. Any other comments or questions? Representative Shalaba.
Thank you, Mr. Chairman. Two things. One, I want to preface by saying that happy to be here fulfilling our obligation to finally pass a budget today, but I want to give a shout out to the veterans in Butler County who I was unfortunately having to miss their graduation from our designated Veterans Treatment Court this afternoon. So I just wanted to say congratulations to them. I think it's a tremendous effort and initiative to have a specialized court for our veterans. They do suffer very unique circumstances, and I think we owe them oftentimes more than a second chance, but also a second look. I do want to say that I have a question, or rather, so not saying, but asking. Typically, we need to file PCRA petitions within 1 year. How is that addressed in here? Is this 1 year of, diagnosis, or 1 year from subsequent diagnosis? How are we addressing the year time frame?
Mr. Chairman, on page 4, line 16, during a 60-day period beginning on the date in which the applicant is notified of the evaluation results, petition the court under subsection D3. So once an inmate is diagnosed, they have 60 days to file their petition.
Okay.
Anything further, Representative?
No, I do think that perhaps this needs, like I said, for the veterans, I think we maybe need to give a second look at some of the language on here. But with that caveat, maybe we can talk about amending this when it's on the floor. But I will vote to move it out of committee.
Thank you. Any other comments or questions? I think this is a really important bill. I think it's well read and well thought out. Second looks are something that we have talked about a lot in our committee. This is a very targeted approach to a community that I think should absolutely have the right, when they learn of a service injury, whenever that is, should be able to bring that to the attention of the sentencing court. So I'd be happy to have conversations with the chair and Representatives Bonner, Kaufman, and Shalab, anyone else, to try to get people more comfortable with this. But I am voting yes, and I encourage all the members to be voting yes. Secretary, please call the roll.
Chairman Briggs,
Yes.
Representatives Abney,
Designation yes.
Carroll,
Yes.
Donahue, Hanbidge, Hohenstein, Howard, Kenyatta, Kincaid, Mays,
Designation yes.
Pielli, Rab,
Designation yes.
Sanchez,
Designation yes.
Schusterman,
Designation yes.
Chairman Kaufman,
No.
Representatives Bonner,
No.
Borowitz, Ecker,
No.
Ham, Kale, Kerwin,
No.
Clunk, Kuzma, Ledbetter, Rigby,
Yes.
Shalaba. This bill passes a vote of 17 to 9.
Thank you, Secretary. House Bill 458 passes bipartisanly, will be reported as committed. Thank you for your work, Chairwoman. Just to mention, I should have did it before, In the paperless theme that we are going, there are agenda QR codes all around the room. People can access the materials through there and take specific notice of the image in the middle because it's in recognition of our veterans. Chair calls up House Bill 490 by Representative Waxman. Chair will first recognize Representative Waxman for brief remarks on the bill. Representative, you are in order. You can take all the time you want.
Hi, thank you so much. Thank you, Chairman, and thank you for calling up the bill. This would expand Pennsylvania's Media Shield law to protect journalists further from giving up confidential sources. It does have a number of provisions to make sure that public safety is protected and that if the material is required for the case, that it can be obtained, but also then protects sources, confidential sources. So appreciate the opportunity and would urge a yes vote.
Thank you. Representative Council, please provide a brief description of the bill.
The bill takes effect in 60 days. There are no amendments.
Thank you, Council. The question is, will the committee report the bill, House Bill 490? Are there any comments on the bill? Representative Ledbetter on the bill.
Thank you, Mr. Chairman. I want to thank the good gentleman from Philadelphia County for bringing the bill before us today for consideration. In reviewing the language of the bill, whether directing this question to council or to the prime sponsor, it seems that the language is silent on the more new forms of media and perhaps rests heavily on the legacy media channels. Does the language in the bill also extend to journalists that are using open platforms, internet platforms, social media, and the like that may also be engaged in the same activity that the bill is seeking to protect, but those individuals fall outside of the traditional media that is outlined in the language?
So I'll
Yep, you're in order, Representative, to answer the question.
I'm sorry.
No,
I'll defer to council to get into all the details, but I think you're raising a really important point. I think there are lots of different types of media, and we want to be careful that we're covering, the appropriate areas. I share those concerns, so I just absolutely. So I'll turn over to council to maybe get into the specifics.
Council, you want to take a stab?
Sure, Mr. Chairman. I think the language could be broad enough to cover those new types of media because the language is for purpose of gathering, procuring, compiling, editing, or publishing news. Can it use some clarity? Potentially, but that may be an area of amendment on the floor, Mr. Chairman.
Thank you, Representative Waxman and Council Vitale. I think that there may be opportunity to collaborate, Representative, for amendments on the bill. Again, I can't stress enough the importance of some of the new and alternative forms of media that have come forward in recent years, especially with the polarization that has been perhaps unfairly perpetuated by legacy media, and ensuring that platform remains open and clear for not only the freedom of speech, but for the protection of journalists, new and traditional alike. So I'll be opposing the bill in Judiciary today, but I'll look forward to potential collaboration for floor amendments. Thank you. Yeah,
I would just to reiterate, I think that is a really valid thing to have a conversation about, to try to make sure that it's covered. I personally, actually, before being elected, I no longer do, but I owned a media outlet that we started. It was an online outlet. It only a couple of years, has only existed for a few years. So I absolutely understand those issues and want to address them. So I look forward to that conversation.
Thank you, Representative. Representative Bonner on House Bill 490. You are in order.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this interesting issue to our committee. Just had a couple questions so I understand the full thrust of the legislation. What do you see as the purpose to protect non-confidential sources and materials? Why should we be protecting that type of information?
I think it's a great question. And for me, it is about protecting the First Amendment and protecting freedom of speech and the right of news gathering organizations to conduct their work without being potentially influenced or intimidated by government in particular, and that making sure that we allow media outlets to do their jobs and that we protect the First Amendment. So to me, that's what this is really about. I wanted to do it in a way that expanded protections that we offer journalists and news gathering individuals without jeopardizing public safety. And I think that this bill walks that line, and that's how it was written.
I don't know if you've had an opportunity to familiarize yourself with the current law in this particular area. And as I read the current law in this particular area, I'm just wondering what the proposed legislation adds. Because seemingly the current law gives broad protection to our media.
Yeah, and I'll maybe ask Council Vitale if you want to, but for me, what this really does is, the PA Media Shield Law, it protects confidential sources, right? And so what this does really is extend those protections to non-confidential sources and news gathering materials. So think about the difference between like an individual source information and documents or other source material that may be covered. There's a lot of information in the work product that journalists generate to create their stories. That work product is often confidential because it includes information that cannot be shared publicly without damaging or hurting or putting somebody at jeopardy. And so this protects that information.
And just reading the current law, it doesn't distinguish between confidential and non-confidential information, but does give broad protection to the news media. I would also note that maybe we should consider extending similar protection to lawyers and doctors and accountants and the clergy, since oftentimes we deal with sensitive information that is non-confidential, yet we would be subject to providing such information upon appropriate request. But you bring an interesting piece of legislation forward, and I look forward to getting a better understanding of it as we move forward, so thank you.
Thank you.
Any other comments on the bill before we go to Chairman Kaufman? Chairman Kaufman, you're in order.
Thank you, Mr. Chairman. Some great points made by my colleagues on the Republican side. I do believe that not everything a reporter touches should be shielded, which almost seems to be where we're headed here in this particular piece of legislation. So today, I'm a no. Maybe we can, fine tune it to make it better. But I am a no today.
And I am a yes. I encourage you to have further conversations with Representative Bonner and Ledbetter, though I do think, and I know you will be very sensitive to broadening it so much just to any media outlet, right? Journalists and news are much different than editorial. So, Secretary, please call the roll.
Chairman Briggs,
Yes.
Representatives Abney,
Designation yes.
Carroll,
Yes.
Donahue,
Yes.
Hanbidge, Hohenstein,
Yes.
Howard, Kenyatta, Kincaid, Mays,
Designation yes.
Pielli,
Yes.
Rab,
Designation yes.
Sanchez,
Designation yes.
Schusterman,
Designation yes.
Chairman Kaufman,
No.
Representatives Bonner,
No.
Borowitz, Ecker,
No.
Ham,
No.
Kale,
No.
Kerwin,
No.
Clunk, Kuzma, Ledbetter,
No.
Rigby,
No.
Shalaba. This bill passes a vote of 14 to 12.
Thank you, Secretary. House Bill 490 passes and will be reported as committed. Thank you, Representative Waxman. Next on the agenda is House Bill 886 by Representative Webster. Representative Webster has joined us today and will be recognized for brief remarks on his bill and then go to council for any additional description if necessary. Representative Webster, you are in order.
Thank you, Mr. Chairman. Hopefully I'll be brief and direct. I'm asking this morning to do a small thing for our veterans, as you did on a previous bill this afternoon, especially since we've said a lot of great things about appreciation in the last few days for everything that our veterans do provide in their service to our country. In this case, I'm asking, and recognizing that many of our incarcerated veterans, and about 8% of our total population in Pennsylvania's jails, prisons, and correction facilities are veterans. Many of them are disabled because of their service. Many have very unique and extensive medical or mental health and substance use disorders, in some cases which led to their offense and their conviction and their sentencing. And when that occurs, the veteran loses their veterans benefits while they're incarcerated. In this case, I'm asking that, they've been convicted, they've served their sentence, they're going to be released. Let's give them a chance to understand what their benefits will be restored. And in many cases, all of their benefits would be restored because they may have left the service with an honorable discharge and now they're available to access those benefits. But they probably don't know that, and they probably don't know how that they or their families could access these benefits. So in this case, we would ask our Department of Corrections to provide a short briefing that specifically says to a veteran leaving the facility, your military and veterans benefits are restored. Here's how you access them. Here's what you can do next. And I will tell you, our departments, our military departments in Washington, D.C. are trying to do a similar thing. Historically, when someone leaves the service, particularly as an enlisted member, they don't get a lot of discussion about what their veterans benefits might be. They get a briefing that asks them to re-enlist and stay on. So we're just sort of following that idea. Let's give them a chance to find their benefits, and then maybe with that resource in hand, they become better citizens after leaving the correction facility. So thank you for your consideration.
Thank you very much, Representative. Council Vitale, anything to add?
Mr. Chairman, the bill takes effect in 60 days. There are no amendments.
Thank you, Council. The question is, will the committee report the bill? Are there any comments on the bill? Representative Pielli.
Thank you, Mr. Chairman. Not just as a veteran, but as a correctional officer and later a correctional counselor, the time for reentry for folks that have done their sentencing is critical. And to be able to match up the veteran with the proper, veteran benefits and other things that can help them, they're limited in their communication to do so. So I've seen it, the days afterwards, it's crucial. This would be a real help, and I thank you for this bill. And I urge everyone to vote yes. Thank you.
Any other comments? Thank you, Representative. Any comments before we go to a vote? Seeing none, I want to thank the representative for, this is something you would hope would have been done in the past, but I can see why it's not, and I really want to thank you for highlighting it and hopefully getting a good result today to take to momentum onto a floor vote. But Chairman Coffin, do you have anything to add? Are there any negative votes on this bill? Hearing none, if the Secretary could please report it as a unanimous vote, and it will be reported as committed. Congratulations, Representative.
Thank you all.
Next on the agenda, House Bill 1385 by our member on the committee, Representative Kincaid. I will recognize Representative Kincaid for brief remarks and then go to Council for any additional information if needed. Representative Kincaid, you are in order.
Thank you, Chairman. This bill seeks to eliminate fines and most fees for our juvenile offenders. What we're finding and what the Juvenile Justice Commission found was that a lot of juveniles are getting caught up in the justice system for longer than is really necessary because they're not able to afford to pay for the fines and fees imposed. That they will have completed all of the other tasks that have been assigned for purposes of rehabilitation, but they can't pay the fines and fees, and so they are just stuck in this sort of continuous loop. And it often comes down to whether or not a youth's family is able to pay. So we're setting up a system where juveniles who are in a better financial situation with their family are able to get out of this system, while those who don't have families that are in good financial situations are caught up, and that is sort of the definition of injustice. So the Juvenile Justice Commission recommended eliminating fines and most fees for juveniles, and so that's what this bill would do. This bill was part of an omnibus bill last session that Representative Miller had sponsored, HB 1382, and so there is, in kind of dividing up that bill, there was a drafting error. So there is language that's contained in here that was not actually supposed to be in there. So I know that you have an amendment to pull that out, but it is really intended as kind of a technical change to pull that out so that we are only focused on fines and fees. This is something that the Juvenile Courts Judges Commission is also in favor of, and in many ways are trying to kind of practice already. So this would just codify something that they have been trying to implement in practice. Thank you.
Thank you very much. And if I said the wrong counsel, Counsel Batt will be providing the additional description, and maybe at the end of the meeting, you all may want to wish her a happy birthday, because it's her birthday. But Counsel, please proceed.
Thank you, Chairman. Yes, House Bill 1385 by Representative Kincaid is a rather broad omnibus juvenile justice bill proposing substantial changes to Title 42. The bill would take effect in 60 days, and there is one amendment.
Counsel, you're in order on the amendment.
Thank you. Mr. Chairman, Amendment 02055 by Chairman Briggs would drastically narrow the scope of the bill, leaving only those provisions relating to restitution and the elimination of summary offenses from juvenile court jurisdiction and the elimination of fines, fees, and costs.
Thank you, Counsel. The question is, will the committee adopt Amendment 02055? Are there any comments on the amendment? I'd like just to add, this was a very interesting hearing. A number of testifiers wanted us to focus in on the Kincaid bill and focus in on the fees and the fines. That amendment takes their recommendation and really tries to tailor this approach. All those, I think that previous bill we had voted on before, but this is a good topic just to try to advance something that a lot of us think is the way to go. So, Counsel, Secretary, please call the roll.
Chairman Briggs?
Yes.
Representatives Abney?
Designation, yes.
Carroll? Yes. Donahue?
Designation, yes.
Hambidge? Yes. Hohenstein? Yes. Howard? Yes. Kenyatta? Yes. Kincaid? Yes. Mays?
Online designation, yes.
Pielli? Yes. Rab?
Designation, yes.
Sanchez?
Online designation, yes.
Schusterman?
Designation, yes.
Chairman Kaufman?
Yes.
Representatives Bonner?
Yes.
Borowitz? No. Ecker?
Yes.
Kale?
Yes.
Kerwin?
Yes.
Clunk? Yes. Kuzma?
Yes.
Ledbetter?
Yes.
Rigby?
Yes.
Shalaba? Yes. Mr. Chairman, this bill passes a vote. I apologize, Representative Ham. Yes. I apologize. Thank you. This bill passes
You didn't
a
get
vote.
the memo? Sure. You
My
got
mistake.
removed. I'm
Thank
just
you.
kidding. Thank you, Secretary.
25 to 1.
The amendment passes, and the question recurs, will the committee report the bill as amended? Are there any comments on the bill, Chairman Kaufman?
Yes, as you go into the bill uses the term actual victim, which is not defined, and I'm just wondering, what is the difference between a victim and an actual victim?
Chairman Kaufman, do you have a place in the bill where this?
In the, let's see, restitution section, C1, under page 15, the engrossed version.
Thank you, Chairman Kaufman, for pointing out the use of actual victim in the bill. I believe that is a reflection of the bill's intent to only have restitution imposed in cases where an individual suffers actual material loss. So there is a possibility of revisiting that phrasing of actual victim on the floor.
Okay. The idea that that was included in the bill makes my skin crawl, because talking about a victim as a victim, to the idea that actual victim, there are a lot of victims when there are crimes. You go through the crimes, there are a lot of victims that may not be an actual victim. So I'm very concerned that that is somehow in the bill and intended that way. I am concerned that the restitution provisions shift focus away from compensating victims toward minimizing what juveniles must pay. And I have concerns that the bill prioritizes the offender over the victim. If it only considers the child's ability to pay, if there is an offender who comes from a well-to-do family and you're leaving the victim unwhole because the child doesn't have the ability to pay, that's a concern to me. So once again, I think this one is not ready for prime time. I get the idea. I think there could be some merit to it, but needs some additional work.
Representative Ledbetter on the bill.
Thank you, Mr. Chairman. I want to thank the good lady for bringing the legislation before the committee for consideration this afternoon. My question is rooted perhaps in both constituent feedback as well as personal experience. In regard to the reforms proposed in the language, Mr. Chairman, my question is able to be directed to council or the prime sponsor of the bill. It seems to seek to eliminate monetary penalties or pecuniary sanctions that would otherwise be used to disincentivize youth from committing the crime. And while as admirable as that may be, where within the language would supplemental restitution measures or disincentivization be rolled out so that way it does not provide a special protection for individuals who may not be able to fulfill or deliver on those monetary penalties or pecuniary sanctions that currently exist today?
Representative Kincaid, you're in order to answer the question.
So fundamentally, that's what the Juvenile Justice Commission found, was that the other kinds of penalties, the rehabilitation directed kinds of programs, was actually what was more effective in terms of deterring future behavior. What they found was that when you're imposing these fines and fees, which are generally under the statute directed or intended to be directed at adult offenders, that is sort of the thought in creating a lot of these, that these are intended for adult offenders. We're not really contemplating the ability of a juvenile to be able to pay them. And in many instances, these kids aren't actually even able to get jobs because they're not old enough. So it does fall on the families to cover those costs. So what the Juvenile Justice Commission and what the juvenile courts judges have looked at and come to the conclusion about is that the these fees are not, in fact, accomplishing the purpose that they're being that they were intended for, because these are fees that are imposed and paid for ultimately by the families instead of the actual kids, where we're looking at, adult offenders would be the ones who would be paying for those fees. And so there's a little bit more of an understanding that the consequences come along with this. So when you're looking at somebody who isn't necessarily going to be paying for this, it's going to be their family. There's a disparity when certain families can pay it and the kid never has any kind of exposure to what that consequence actually means. And then there's other kids who would have the exposure to it. This is something that is impacting their whole family and their ability to put food on the table and pay rent. So there's sort of a disproportionate understanding of the impact for that. So that was the recommendation of the Juvenile Justice Commission and the juvenile court judges, is that these fees are not actually accomplishing what they're supposed to accomplish. And so, it allows them to actually hone in on the rehabilitation side of things without needing to impose these fees.
If I may, Mr. Chairman, Representative Kincaid, thank you for that. I appreciate the crafting of the legislation being based off of that feedback. I have to reconcile that with personal experience because my hesitation does not come from a position of privilege. My grandfather was from Westmoreland County and got stationed in the Philippines, married my grandmother, and after having 7 kids, abandoned her outside of Nellis Air Force Base. And so my dad and my uncles and aunts historically were always late to the period after lunch because they were eating food out of trash cans. And despite that impoverished lifestyle, my grandmother delivered to provide for all of them. And I understand the manner in which this recommendation is being crafted, but hearing stories from my Lola and from my uncles and aunts, part of the reason that the family rallied together to make sure that no one got in trouble was because of some of the penalties that existed that simply weren't available to them. And so rather than removing a tool to ensure that laws are followed and incentivized those laws to be followed, I don't believe that removing it is the option. I can appreciate the disparity that exists between classes and people groups because, again, I can speak to that from personal experience. But I hesitate to remove tools in a manner that's exhaustive, and so now I'll be opposing the legislation in committee, but I'll look forward to possibly collaborating to identify a path forward for the floor vote.
Thank you, Representative Leibert. Representative Hohenstein on the bill.
Thank you. I have a couple quick questions that I believe the sponsor can answer relatively quickly. You mentioned the Juvenile Justice Commission and the juvenile judges. This legislation specifically is one of the policy recommendations that was made after that commission met and issued its recent report, correct?
Yes.
Okay. That commission, if I'm remembering correctly, does include victim representatives in part of its membership, correct?
Yes.
Do you know what those victim members had as comments or as particular perspectives that they brought when this policy, did they express anything as far as you remember?
The commission met before I was in office,
Right.
and they released the report in March of 2021. So I was not, kind of exposed to that. So that might be
Right.
a better question for council or for
Yeah.
the chairman.
It just strikes me that this is something that we have already vetted concerns from victims groups. I know that even outside of a judicially recommended restitution, that there is a victim relief fund available both in many local courts and also at the state level to make sure that victims are made whole to the best that is possible through monetary means. And I think this policy, which focuses on a rehabilitative structure of justice rather than a punitive one, is a way that we need to go, especially when we are talking about juveniles and juvenile offenders, because that is the time when rehabilitation, I believe, is most effective, and providing alternative means for kids who commit crimes to be able to change the course of their lives in positive ways. So I support this bill wholeheartedly and thank the maker for bringing it forward.
Thank you, Representative. Any other comments? Representative Bonner on the bill.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this legislation forward. You always bring very significant and sensitive matters to us, so I thank you for doing that. I know in my practice, I've never been a fan of fines, and frankly, I have seldom seen them imposed. Fines have not been a part of the adult criminal justice system very often, other than traffic offenses. Generally, I would say that I could be very supportive of eliminating fines. I just don't think they serve any particular purpose. They're seldom used, and they're sometimes used more out of anger than they are out of justice. So that part of the bill, I think I could find myself supporting. One of the concerns, though, I have is I believe you indicated that you were going to eliminate summary offenses as a delinquent act. Is that correct? Okay. My concern would be, at least at this point in time, the elimination of summary offenses as a delinquent act. And the reason for that is that I have found that the police will often attempt to, with juveniles, to charge the less serious crime possible, particularly recognizing their sensitive nature of a young offender. And I'm fearful that if we eliminate the summary offense as a potential outcome and disposition as a juvenile delinquent act, we'll find our police charging the misdemeanor comparable statute. So I think it may be counterproductive relative to dealing with juveniles. So as I say, I would be open to eliminating the fines, and but I do think we should consider retaining the summary act jurisdiction of our juvenile courts to allow the police to charge at a lesser level than they otherwise might. They might just bump that grade up to get in front of a juvenile judge. That would be my concern.
Yeah, I can certainly see the potential for unintended consequences on that. I mean, this ultimately takes the recommendation of the juvenile court judges and the Juvenile Justice Commission, but I'm happy to have a conversation about how we could potentially ensure that you know, the goal of why we're trying to take that out is accomplished, rather than basically resulting in you know, higher charges for juveniles.
Thank you, Representatives. Any other comments? Secretary, please call the roll.
Chairman Briggs?
Yes, all the Democrats will be yes. I'll try to speed this up.
Okay. Chairman Kaufman?
No.
Representatives Bonner? No. Borowitz? No. Ecker?
No.
Ham? No. Kale? No. Kerwin?
No.
Clunk? No. Kuzma? Ledbetter? No. Rigby? No. Shalaba? No. This bill passes as amended, a vote of 14 to 12.
Thank you. House Bill 1385 passes and will be reported as amended. Next on the agenda is House Bill 1432 by Representative Delosier. I will recognize Representative Delosier for remarks on her bill, followed by a brief description by counsel. Representative Delosier, you are in order.
Okay. Thank you, Mr. Chairman. I appreciate the opportunity to speak today in support of House Bill 1432. As a longtime advocate with victims, and this is a direct response to a bill, to sponsor this bill from my local DVSCP and a constituent who has worked her way as from a victim to a survivor. But this was her experience, and this is what instigated this bill. The bill proposed is a targeted but important amendment to Title 23, specifically within the PFA Act provisions. And at its core, House Bill 1432 is about clarifying definitions. These definitions determine who is eligible for actual protection under a PFA, and this bill updates the stalking definition to align it with PA's stalking statute and gives our law enforcement the ability to make sure that a PFA is worth more than the paper that it's printed on. Why is this necessary? Because the language that we use in our laws matter. It shapes how our courts interpret the protections and how law enforcement responds, and most importantly, how survivors of abuse access the help that they need. Over time, we've seen how ambiguous or outdated definitions can leave individuals without the legal tools to protect themselves. And I just wanted to share some statistics. This is a real example from my own district where a victim currently enrolled in the Address Confidentiality program. This is a program that's designed to shield survivors from being located by their abusers. Despite this, her stalker has still found her and continues to harass and intimidate her. This is not a breach of privacy, it's a failure of our system to protect her. And she is not alone. This is just one example of why an enhanced protection is urgently needed, and why I have introduced also House Bill 1419 to deal with PFAs and make them stronger and worth more for our victims. Some of the data that backs this up: 37.1% of Pennsylvania women and 30.4% of men have experienced intimate partner physical violence, sexual violence, or stalking in their lifetimes. In 2024 alone, 41,900 new PFA orders were ordered across the Commonwealth, and this number continues to rise every year. On a single day in 2023, 3,102 victims were served by domestic violence programs here in Pennsylvania, and 76% of women killed by an intimate partner were stalked first. Them being stalking is a chilling reminder of how stalking often escalates to lethal violence. This bill ensures our statutes reflect the realities of our modern relationships and the diverse forms of domestic abuse that many Pennsylvanians face, and it's a step towards making our legal system more responsive and more just. I just want to be clear, this is not about expanding the law recklessly. It's about precision and ensuring that those who need protection can get it, while maintaining the integrity of our judicial process. We've worked closely with legal experts, advocacy organizations, and law enforcement to ensure that this language is both effective and enforceable, which is something that sometimes doesn't happen. I respectfully urge the committee's support of 1432, and I'm glad to answer any questions that I can. Thank you, Mr. Chairman.
Thank you very much, Representative. Council, anything to add? That was a very good overview.
Thank you, Mr. Chairman. This bill takes effect in 60 days, and there are no amendments.
Terrific. The question is, will the committee report the bill? Are there any comments on the bill, House Bill 1432? I saw a hand. Are there any negative votes on House Bill 1432? Yes. Yes. Okay. Are there any other negative votes? No. So all Democrats will be a yes on the representative's good bill.
And all Republicans, will, except Representative Borowitz, will be yes.
Okay, so Secretary has that?
1 no.
Yes, this bill passes a vote of 25-1.
Great. House Bill 1432 passes and will be reported as committed. Thank you, Representative, for the good work. Yep. Just remember who was the one no vote. Was it on our side? I'm just teasing the representatives. The chair calls up House Bill 1476 by Representative Mihalik. I don't believe. Is Representative Mihalik online? Okay. Council, please provide a brief description of House Bill 1476.
Thank you, Chairman. House Bill 1476 by Representative Mihalik expands the definition of intimidation in Title 42, Chapter 62A, enabling adults to seek protection from intimidation orders. This bill takes effect in 60 days, and there are no amendments.
Thank you, Council. Question is, will the committee report the bill, House Bill 1476? Are there any comments on the bill? Are there any, so all Democrats will be yes.
And all Republicans except for Representative Borowitz will be yes.
Thank you.
So what is
Yes, this bill passes a vote of 25 to 1.
25 to 1. House Bill 1476 passes and will be reported as committed. Chair calls up House Bill 1479 by Representative Marcel. I believe it's co-sponsored by Representative Labs, who was going to make some brief remarks if she is here. Okay. Council, please provide a brief description of the bill.
Thank you, Mr. Chairman. House Bill 1479 by Representative Marcel amends Title 23 in Chapter 61 to enable judges to include social media restrictions in protection from abuse orders. This bill takes effect in 60 days, and there is one amendment.
Council, please provide a brief description of the amendment introduced by Representative Chairman Kaufman.
Thank you, Mr. Chairman. Amendment 02092 by Chairman Kaufman clarifies the applicability of the social media restriction and further amends Title 42, Chapter 62A to enable judges sitting in protection from sexual violence and protection from intimidation matters to impose the same social media restrictions in those orders as well.
Thank you. Council, question is, will the committee adopt Amendment 02092 offered by Chairman Kaufman? Are there any comments on the amendment? Do you have anything? Are there any comments on the amendment? I keep hearing something behind me. I'm sorry. I need like a rearview mirror.
Yeah.
Are there any negative votes on the amendment? Seeing none, the amendment passes. Are there? We will now be question concurs. I lost my place. Will the committee report the bill as amended? Are there any comments on the bill as amended? Representative Borowitz, you are in order.
Thank you, Chairman. The reason I'm opposing these, obviously I'm not for women being harmed in any manner, but I believe it was, 2018, that there was an act passed, sadly, by Republicans that took away due process. And so due process was taken away through that act, and so that's why this package of bills now brought on by Democrats, obviously I'm not for women being harmed, but just the lack of due process through that passing in 2018 is where my concern comes from. Thank you, Chairman.
Okay. Any other comments before I just clarify? I mean, maybe you don't know all your colleagues, but these last few bills are introduced by Republican members.
Yeah, I understand that. Thank you so much,
Okay.
Chairman.
Yep. No, you had said it was being brought up by a Democrat. So I will be voting yes on this bill. I do think it needs some more work to work on the definition of social media to try to tighten that up. But for today's purpose, I will be voting yes. Any other comments before we go to a vote? No. So why don't we do a roll call? Because, I love
For kicks and giggles.
Yeah.
Okay. Chairman Briggs.
Yes.
Representatives Abney.
Designation yes.
Carroll. Yes. Donahue.
Designation yes.
Hambidge. Yes. Hohenstein.
Yes.
Howard. Yes. Kenyatta. Yes. Kincaid. Yes. Mays.
Designation yes.
Pielli. Yes. Rab.
Designation yes.
Sanchez.
Designation yes.
Schusterman.
Designation yes.
Chairman Kaufman.
Yes.
Representatives Bonner. Yes. Borowitz. No. Ecker.
Yes.
Ham. Yes. Kale. Yes. Kerwin.
Yes.
Clunk. Yes. Kuzma. Yes. Ledbetter. Yes. Rigby. Yes. Shalaba. Yes. Mr. Chairman, this bill passes as amended, a vote of 25 to 1.
Great. House Bill 1479 passes and will be reported as amended. Thank you very much. Next on the agenda, we are going to be going over House Bill 1671. Next on the agenda will be House Bill 1891, offered by Representative Bellman. Representative is with us. He will be recognized for some comments on his bill, followed by council's additional description. Representative, you are in order on your bill.
Thank you, Chair. House Bill 1891 updates a process that has been in place for decades. The system of the Commonwealth uses to record handgun sales. Under current law, every time a handgun is sold, a record of that sale is created and sent to the Pennsylvania State Police. These records are one of the ways law enforcement agencies can identify patterns and trends to help them investigate gun trafficking and illegal sales. At the moment, many of those records are still being transmitted on paper, which can slow down the process and make data analysis more difficult. This bill takes a straightforward step towards modernizing by requiring any licensed firearm dealer who sells more than 20 firearms per year to submit those sales through the state police's already existing electronic records of sales system. The electronic system already exists and is used successfully by many dealers. This bill doesn't change what data is collected or create new reporting requirements. It simply changes how the data is transmitted. The goal is to make the process more efficient for both dealers and law enforcement, reduce paperwork, and ensure that information is accurate and available in real time. I urge everybody to vote yes. Thank you, Chair.
Thank you, Representative. Good job. Council, any additional information?
Yes, Mr. Chairman. The bill allows exempt dealers to opt into the electronic filing system if they choose. And also, beginning in 2027, the Pennsylvania State Police shall conduct an annual review of the transaction of each licensed dealer over the past calendar year to determine who is exempt from the use of electronic application record of sale system. The Pennsylvania State Police shall notify each licensed dealer of an exemption to the use of electronic application record of sale no later than April 1st of each year. Mr. Chairman, the bill takes effect in 60 days, and there's one amendment.
Council, please provide a brief description of the Briggs Amendment.
Mr. Chairman, Amendment 02106 makes it crystal clear that nothing in this section shall be construed to allow a government or law enforcement agency or an agent of a government or law enforcement agency to create, maintain, or operate a registry of firearm ownership within this Commonwealth. This language reaffirms Section 6111.4 of the Uniform Firearms Act as well as case law.
Question is, will the committee adopt Amendment 02106? Are there any comments on the amendment? I think this amendment is pretty clear. It's just reaffirming current law to make sure that the concerns regarding a registry is clarified, that there shouldn't be. Any negative votes on Amendment 02106? Seeing none, if the Secretary could report Amendment 02106 as passing unanimous. Briggs Amendment passing unanimous. I'd like to hear more of that. The amendment passes, and the question recurs, will the committee report the bill as amended? Are there any comments on the bill as amended? Representative Ledbetter on the bill as amended, House Bill 1891.
Thank you, Mr. Chairman. I appreciate the good gentleman for bringing the legislation before the committee for our consideration today. I also can appreciate sitting on the House Republican AI Opportunity Task Force as well as the House Committee on Communications and Technology that there are opportunities for technology to identify patterns. When you have judges handing down different verdicts based on the quality of their lunch, I think it's very apparent that the manner in which technology can improve the way in which our societies function is certainly something to be open to. However, when it comes to tracking patterns when exercising our constitutional rights. I have concerns. So whether that is the limited time that I had to review this language, or if it is a manner in which I can work with the prime sponsor of the bill to either address my concerns or collaborate in a manner to alleviate them prior to a floor vote. I'll be opposing the bill in committee today, but appreciate the outside of the box thinking and will look forward to future discussions. Thank you, Mr. Chairman.
Thank you. Any Representative Bonner on the bill? You are recognized.
You can certainly call me old-fashioned, but I still think we should have the paper potential to be used. So I'll be a no vote.
Any other comments on the bill? Chairman Kaufman.
I do appreciate Chairman Briggs and your attempt to clarify the bill. I genuinely don't see the need to move this bill forward at this moment. I know there is a continued distrust of maybe not what this government will do with this data, but what a future government would do with the data. And there is an extraordinary distrust of government. And so I'm just going to go with a no.
Okay, any other comments before we go to a vote? So I trust law enforcement, specifically law enforcement Commonwealth of Pennsylvania State Police. But 6 to 9 month backlog, huge amount of paper. The amount of crimes that could be solved during that period is unknown. But I think just the efficiency. We introduced this bill last session. We voted out of committee last session. We had a floor vote. A majority of the members on the floor voted for it. Was careful how I said that. And we gave sufficient notice, I think an extra day with the holiday for the committee members to review the agenda. I'm prepared to vote yes. I think it's a good yes vote. Helps law enforcement, helps our communities. And I want to thank Representative Bellman for bringing it forward again. Secretary, please call the roll.
Chairman Briggs?
Yes.
Representatives Abney?
Designation yes.
Carroll? Yes. Donahue?
Designation yes.
Hambidge? Hohenstein? Yes. Howard? Yes. Kenyatta?
Yes.
Kincaid? Yes. Mays?
Designation yes.
Pielli? Yes. Rab?
Designation yes.
Sanchez?
Designation yes.
Schusterman?
Designation yes.
Chairman Kaufman?
No.
Representatives Bonner? No. Borowitz?
No.
Ecker?
No.
Ham? No. Kale? No. Kerwin?
No.
Clunk? No. Kuzma? Ledbetter? No. Rigby? No. Shalaba? No. This bill passes a vote of 14 to 12.
Thank you. House Bill 1891 passes and will be reported as amended. Congratulations, Representative. Next on the agenda is we're going to go over the Davidson bills. No, I'm just kidding. Next on the agenda is House Bill 1908 by Representative Davidson. Rep. Davidson will be recognized for remarks on the bill, followed by council. Representative, you're in order.
Thank you, Mr. Chair, and thank you for taking the time to consider these bills in committee today. I'll try and keep my remarks brief, but just wanted to share a little bit of my interest in these bills and how I got to be involved with this subject matter. Earlier this year, I visited with some of the leaders at a local domestic violence shelter, and they brought up this issue about repeat offenders for PFAs. And asked me to get engaged on the subject matter, pointing me to a couple other members, some of which are in the room today, Representative Kincaid being one of them, who were already engaged in the space on this issue. I'm not typically excited about legislation that increases penalties or creates new penalties, but as I did a little more research into this specific area, a couple things came up. So let me just talk about 1908 in particular, and then we'll save 1909 for next. This bill creates a system of escalating or ratcheting up penalties for repeat violators of PFAs. In addition, it does a second thing. It mandates immediate statewide data sharing. Many of these violations are not being reported to law enforcement. and or to the statewide database. And on the first change, many of these violators or repeat violators are met with the same low-level fine or no fine at all, or the same low-level probation from the judge, or very little. And what happens is they continue to offend. And so this bill would create, ability to ratchet up fines for the judge or and other penalties, as well as the mandatory reporting. And it gives more tools to our judges to keep law enforcement safe. I will mention just less than 2 months ago, 5 officers in York County were ambushed and 3 were murdered when they were attempting to serve a warrant for a domestic violence case. So this is very real, and this is one of the ways that we should be supporting our law enforcement community. And I would ask members for an affirmative vote. Thank you, Mr. Chair.
Thank you. Thank you, Representative, for your work on this and getting it to this point. Question is, will the committee report the bill, House Bill 1908? Are there any comments on the bill? Representative Kincaid, you're in order.
Thanks, Chairman. I was glad to work with Rep. Davidson on this. And again, I share his lack of enthusiasm for adding additional penalties and additional crimes when it is unnecessary. But I think this is where we run into a situation that it is necessary. We have not, in fact, provided the tools for our judges, for our district attorneys, for our police officers to be able to adequately hold accountable people who repeatedly and flagrantly violate PFAs. And this gives a measured approach to holding people to greater accountability as they continue to violate court orders. And to Rep. Delogier's point earlier, a PFA should be worth more than the paper that it is printed on, and this is a way to ensure that that is the case, both by reporting to the statewide database and by allowing for greater penalties as people continue to demonstrate an intent to violate a court order. Thank you.
Thank you, Representative. Any other comments on House Bill 1908? Seeing none, if Secretary could call. Are there any negative votes on House Bill 1908? Secretary, please call the roll.
Chairman Briggs?
Yes.
Representatives Abney?
Designation, yes.
Carroll?
Designation, yes.
Donahue?
Designation, yes.
Hanbidge? Yes. Hohenstein?
Yes.
Howard? Yes. Kenyatta? Yes. Kincaid? Yes. Mays?
Designation, yes.
Pielli? Yes. Rab?
Designation, yes.
Sanchez?
Designation, yes.
Schusterman?
Designation, yes.
Chairman Kaufman?
No.
Representatives Bonner? No. Borowitz?
No.
Ecker?
No.
Ham?
No.
Kale?
No.
Kerwin?
No.
Clunk? No. Kuzma? Ledbetter?
No.
Rigby? No. Shalaba? No. This bill passes a vote of 14 to 12.
Thank you, Secretary. House Bill 1908 passes and will be reported as committed. Next on the agenda is House Bill 1909 by Representative Davidson. If the representative could address 1909, followed by council. Do you have anything to add on 1909? You're in order.
Thank you, Mr. Chair. Just a couple things on 1909. So this is it's a companion bill. They kind of run together, and there is an amendment on this bill to clear up some constitutional issues with some recent Supreme Court precedent. So we were able to find an amendment to deal with that. But this is a sentencing upgrade or grading enhancement for a variety of crimes that are often committed while violating a PFA. I think it's important to note, and I neglected to mention 1908, but I'll mention it here. We have these enhancements or increasing penalties in many other instances in the criminal code. Just traffic violations is one example. Repeat offenders for speeding tickets have increasing penalties over time. So this isn't a novel idea, but it's one that we're applying to the victims and to the cases of domestic violence, domestic abuse, and sending a message that we stand with survivors. Thank you, Mr. Chair.
Great. Thank you very much, Representative. Council, anything to add?
Yes, Chairman, this bill takes effect in 60 days, and there is one amendment.
Council, please provide a description on the amendment, the Briggs Amendment 02114.
Thank you, Mr. Chairman. Amendment 02114 by Chairman Briggs guts and replaces the bill, which originally amended Title 42, Chapter 97 to create a grading enhancement. Instead, the amendment now amends 10 provisions of Title 18 to institute grading enhancements for misdemeanor offenses that are likely to co-occur with PFA violations. Thank you.
Great. The question is, will the committee adopt Amendment 02114? Are there any comments on the amendment? Are there any negative votes on the amendment? Secretary, please call the roll. All the Democrats will be yes. I'll try to get to the bill signing.
Chairman Kaufman?
No.
Representatives Bonner? Borowitz? Ecker?
No.
Ham? No. Kale? No. Kerwin?
No.
Clunk? No. Kuzma? Ledbetter? No. Rigby? No. Shalaba? No. Mr. Chairman, this amendment passes a vote of 14 to 12.
Thank you. Amendment passes, and the question recurs, will the committee report the bill as amended? Are there any comments on the bill as amended? Representative Kincaid, you're in order on the bill as amended.
Thank you, Mr. Chairman. And again, I was glad to work with Rep. Davidson on this. But you know, we are consistently seeing an uptick in people who will commit violence against women in particular, and then go on to commit other far more serious crimes, including mass shootings. There is it co-occurs often. The history of violence against women, the history of domestic violence, and then you know, moving on to more serious crimes. So you know, in the same way that we have taken animal cruelty into account and are trying to sort of catch people earlier, so that we can prevent these crimes from occurring by increasing penalties against animals, for crimes against animals, we are doing the same here in order to address the fact that you know, we have to take PFAs more seriously, and we have to ensure that people who have PFAs are able to actually count on them to provide some level of protection. And this bill, I think, as amended, in particular, helps to ensure that we are holding people accountable for what has been considered very low-level offenses, and really need to be taken more seriously if you're violating a PFA. So thank you, Mr. Chairman.
Great, thank you, I agree. Any other comments on the bill? Any negative votes on the bill as amended? No. Secretary, so I think this is, the representative hit the nail on the head, that we're trying to identify before it becomes much more serious by enhancing the penalties of that trajectory. So I'm a solid yes. All the Democrats will be yes. Secretary, continue.
Chairman Kaufman?
No.
Representatives Bonner? No. Borowitz?
It's a no.
Ecker?
No.
Ham? No. Kale? No. Kerwin?
No.
Clunk? Yes. Kuzma? Ledbetter?
Yes.
Rigby?
No.
Shalaba? Yes. Mr. Chairman, this bill passes as amended, a vote of 17 to 9.
Thank you. In a bipartisan fashion, House Bill 1909 passes and will be reported as amended. Thank you very much, Representative. Sorry. Next on the agenda is calls up House Bill 1935. Council, please provide a brief description of the bill.
Mr. Chairman, House Bill 1935 by Chairman Briggs directs the Pennsylvania Commission on Sentencing to create a sentencing enhancement for terroristic threats or swatting against a school entity or and provides for additional restitution to cover the cost of supplies, equipment, materials, salaries, overtime pay, and other wages of affected employees and first responders. The bill takes effect in 60 days. There are no amendments.
Thank you. The question is, will the committee report the bill, House Bill 1935? Are there any comments on the bill? Representative Bonner on the bill.
Thank you, Mr. Chairman. I do like the approach of this particular bill in that it is being sent to the Commission on Sentencing for their review and input. I serve on that commission, and it's a very effective commission in analyzing potential criminal offenses and whether there will be an enhancement. So unlike some of the other legislation we considered today, which is not going through that process, this particular bill does, and for that reason, I'll be supporting it. Thank you.
Waiting for a but. Thank you, Representative. Any other comments or questions on the bill? So I want to echo what Rep. Bonner said. We are trying a much targeted approach. I serve on the PASHE board, State System of Higher Education. These instances are happening specifically on college campuses. I represent part of Villanova's campus, and we all saw on national news what happened there. But we were trying to target it as tightly as possible and get the expertise from the Sentencing Commission. So I encourage all the members to vote yes on this. Are there any negative votes? Yeah. Okay. Oh, do you have comments? Yeah, I'm sorry. I thought we went to comments. Representative Ledbetter, you are in order.
Apologies, Mr. Chairman.
No, my bad.
Understand the hour is late. In regard to the bill, and for clarity, apologies, Mr. Chairman. My comments are on House Bill 1935. Am I in order?
Yeah, you're in order. Yes, you're in order.
Thank you, Mr. Chairman. Does this extend to the science labs or physical facilities of any public cyber charters or other alternative education facilities, or is this language specifically tailored to public school campuses?
Do you want to answer that? It's all school entities, so it would be included. But yeah, Council.
Mr. Chairman, the definition of school entity is a public school including a charter school or a cyber charter school, a private school, a non-public school, an intermediate unit, or an area career or technical school operating within the Commonwealth.
Thank you, Council Vitale, and thank you, Mr. Chairman. I'll just reinforce the emphasis there that then this would also extend to religious schools, private schools, and the other organizations that Council Vitale outlined. So thank you, Mr. Chairman.
Great, thank you very much. I apologize. Any other comments before we go to roll call? Okay, I'm not missing anyone? Okay, any negative votes? Secretary, we will do a speed roll call. All the Democrats will be voting yes.
Chairman Kaufman?
Yes.
Representatives Bonner?
Yes.
Borowitz? No. Ecker?
Yes.
Ham? Yes. Kale?
Yes.
Kerwin?
Yes.
Clunk? Kuzma? Ledbetter?
Yes.
Rigby? Yes. Shalaba? Yes. Mr. Chairman, this bill passes a vote of 25 to 1.
Thank you. House Bill 1935 passes and will be reported as committed. Next on the agenda, we're getting close to the end. Senate Bill 418 by Senator Baker. Council, please provide a description of the bill.
Mr. Chairman, Senate Bill 418 by Senator Baker clarifies that vacancies in the Office of District Attorney in counties 2A through 8 class counties shall be filled by the first assistant for the balance of the unexpired term and prohibit home rule charter municipalities from enacting laws pertaining to the Office of Attorney General or the filling of vacancies. This bill unanimously passed the Senate on October 20th, 2025. We also passed this earlier as House Bill 1423 unanimously out of committee. The bill takes effect immediately. There are no amendments.
Thank you. Council, the question is, will the committee report the bill, Senate Bill 418? Are there any comments on the bill? Seeing none, are there any negative votes on the bill?
Yes.
Baker?
Oh, yeah, no.
Yeah. I'm not sure you'll have a bill in front of her, but that's never good. So seeing no negative votes, we will record it as unanimous vote. Secretary, please call it unanimous. Senate Bill 418 passes and will be reported as committed. Next on the agenda is House Resolution 58 by Representative Kazim. Let's go to description by council and then see if anyone has comments on the resolution.
Mr.
Counsel?
Chairman, House Resolution 240 by Representative Kazim urges Congress of the United States to pass a constitutional amendment that provides that neither slavery nor involuntary servitude may be imposed as a punishment for a crime. Once passed, a copy of this resolution would be transmitted to the President of the United States, the presiding officer of each House of Congress, and each member of Congress from Pennsylvania. Thank you, Mr. Chairman.
Thank you, Council. The question is, will the committee report the resolution? Are there any comments on the resolution? Do you have anything?
Yeah.
Oh, Chairman Kaufman.
Yeah, I'm interested. House Bill 1385 that we passed earlier in this meeting, I think criminal defendants can be required to work or perform community slavery. Oh, I mean service as part of their penalty. So I think we just authorized slavery in 1385. So I'm. It's just, it's just a little bit of crazy. So I'll be voting no.
Great. Representative Ledbetter on the resolution.
Thank you for the latitude, Mr. Chairman. I apologize to the minority chair, Kaufman, and you for being out of order slightly. Appreciate the consideration. Once again, celebrating Filipino heritage and understanding the atrocities that different people groups have navigated and experienced, I can appreciate the representative's intent in bringing this resolution forward. However, we have had other bills considered in prior sessions as well as introduced this session for floor votes that would speak out against slave labor in China for solar panels or for batteries or for things that would have actual impact in leading the world toward freedom and opposing the atrocity that slavery is. And yet we have had votes. We have had votes where those bills have been struck down. And so I just want to ensure continuity in our commitment against atrocities like this. And so I would encourage my colleagues that when other bills come forward that also deal with the same subject matter, that we maintain this spirit of leadership to speaking out and opposing this type of affront to humanity. Thank you, Mr. Chairman.
Thank you. Any other comments on the resolution? Representative Kenyatta.
Thank you, Mr. Chairman. I would just note that only in this committee could a resolution condemning the most heinous atrocity in human history, and to the good gentleman's point, an atrocity that is still being perpetrated in other parts of the country. Only here is that not a layup. And I know it might have been a slip of tongue, but community slavery or any type of slavery should not be something that we even have to have a debate about. I would hope that as we had a number of unanimous votes today, that this will be an easy unanimous vote. But only here is this a debate, and I just want to highlight that, Mr. Chairman.
Thank you, Chair Kaufman.
Well, somewhere I'm missing the slavery in America. And the involuntary servitude, my assumption was in the criminal justice system, which would just be authorized by House Bill 1385. So no one's promoting slavery. We're trying to figure out what we're actually trying to solve here.
Representative Kincaid on the resolution.
Thank you, Mr. Chairman. To the chairman's question, what we're trying to solve here is we allow under the amendment that prohibited slavery the ability to use individuals who are incarcerated as basically slave labor. And regardless of whether or not it happens, I think that this resolution speaks to the idea that we should not have that in our Constitution. At no point in time should we authorize even the ability to enslave people, whether they're incarcerated or not. So whether we view community service as akin to that, I think that if we were to repeal that aspect of the 13th Amendment, we could certainly revisit our criminal codes and eliminate anything that would be considered akin to that. But I think that it's pretty easy to support something that just says that even someone who's incarcerated should not be put into slavery conditions, and that was in fact a mistake in what we passed as the 13th Amendment. It shouldn't be an option, and encouraging Congress to change things, I think, is the least that we can do at our level.
Great, thank you. Any other comments or questions before I guess we have to go to a roll call? We will go to roll call. I encourage all the members to vote yes. Secretary, all Democrats will vote yes.
Okay. Chairman Kaufman?
No.
Representative Spawner?
Yes.
Borowitz?
No.
Ecker?
No.
Ham?
No.
Kale?
No.
Kerwin?
No.
Clunk? Kuzma? Ledbetter? Rigby? Shalaba? Mr. Chairman, this bill passes a vote of 15 to 11.
Thank you. The resolution passes and will be reported as committed. Finally, on the agenda is House Resolution 240, introduced by a group of legislators, Marcel, Labs, Mihalik, Major, and Tomlinson. Is Labs online? Council, please provide a brief description of the resolution, House Resolution 240.
Thank you, Mr. Chairman. This House resolution would recognize the month of January 2026 as Stalking Awareness Month in Pennsylvania. There are no amendments.
Thank you, Council. The question is, will the committee report the resolution, House Resolution 240? Are there any comments on the resolution? Seeing none, are there any negative votes on the resolution? Hearing no negative votes, if the Secretary could please report it as unanimously supported. House Resolution 240 passes and will be reported as committed. I have a reminder before we adjourn. Committee will be holding an informational meeting on November 19th at 10 a.m. in the Majority Caucus Room 140 Main Capitol to learn more about the collection of DNA in the criminal justice system. Thank you for everyone's attention. This meeting stands adjourned.